Litigation examples and the playbook for structuring back-to-back deals defensibly. Hello, yet again, this is Forrest Owens. I'm an aviation lawyer, a private pilot, and an FAA licensed airframe and power plant mechanic. Finally, let's discuss what the public record teaches us. Because aircraft lawyers should never pretend these risks are theoretical. The first example is Brindley Holdings, Inc. versus RSH Aviation, Inc., a federal case out of Illinois. The public record reflects a fight between two aircraft intermediaries, each trying to control a deal in order to buy an aircraft and resell it in a back-to-back structure. You do not need to know or be aware of every procedural detail to see the lesson. The court record captures the commercial reality that in aircraft markets, especially when inventory is scarce, multiple intermediaries may try to position themselves between the seller and buyer at the same time. This creates obvious pressure around exclusivity, confidentiality, interference allegations, and who actually has the right to control the transaction. The memorable lesson is this. In back-to-back aircraft deals, the first battle is not often over the aircraft, it is often over the lane. The second example is Zuma Seguros CA versus Worldjet of Delaware, Inc. in the Southern District of Florida. There, the public records reflect allegations that the defendant wrongfully denied access to maintenance and logbooks and fraudulently induced the purchaser when it allegedly lacked ownership of the aircraft. Whatever one thinks about the merits of the parties' positions, the case is a powerful illustration of the exact risks that back-to-back and intermediate transactions create. Uncertainty over ownership, uncertainty over assignment, and restricted access to the records that define the aircraft's condition and value. In large turbine work, that combination is combustible. A third example is Jet Experts LLC versus Asia Pacific Aviation Limited, involving a Bombardier Challenger 300. That case was not framed as a classic broker back-to-back dispute, but it is highly instructive because the federal court ordered specific performance and directed transfer of legal title, possession, and control of the aircraft after finding the seller had unjustifiably terminated the deal. The lesson for back-to-back transactions is stark. If a party in the first leg thinks it can walk away because a better downstream opportunity appears, a court may not agree. In a moving market, a paper right to flip value can become a court order to perform. And the deepest legal warning remains Philco Aviation versus Shackett from the Supreme Court of the United States. Philco was not about a modern large cabin broker chain, but it remains foundational because the court made clear that undocumented or unrecorded transfers cannot be relied upon against innocent third parties. That principle matters profoundly in back-to-back closings. The market may run on calls, emails, and urgency. Title priority still runs on documentation and recordation. And here's something I would like you to keep in mind and remember. Aircraft deals may begin in conversation, but they are won or lost in the chain of paper. So, how do you structure a defensible back-to-back transaction for a large turbine aircraft? First, decide whether the intermediary is truly buying and reselling or merely facilitating. If it is facilitating, Document honesty as a brokerage or agency agreement. Do not simulate ownership if the intermediary is not actually taking the rights and burdens of ownership. Second, if the intermediary is truly in the chain, mirror carefully, with some exceptions, the rights and deadlines across both purchase agreements. Inspection access, records access, discrepancy standards, delivery conditions, casualty allocation, deposit rules, and closing mechanics should all be intentionally considered and aligned as appropriate, not casually copied. Third, centralize the closing architecture. Use one escrow agent that can address both legs: title releases, wire timing, lien payoff, and what happens if one leg performs and the other fails. Large turbine deals are not forgiving of improvisation at 4:45 p.m. on closing day. Fourth, run enhanced diligence on all parties and on all funds. In today's market, that means knowing who the intermediary really is, who owns the buyer, whether any sanctions or export control issues exist, and whether commercial explanation for the chain makes sense. A structure that cannot survive a basic "why is this deal built this way" conversation is not ready to close. Fifth, be disciplined about disclosures. Pricing can remain private if the parties choose. But the role of the intermediary, the source of deliverables, and any limits on records access or authority should not be disguised. Sophisticated parties can easily price around known constraints. They litigate about concealed ones. Sixth, remember the large turbine aircraft overlay. Confirm maintenance program status, engine and APU enrollment, life-limited part status, damage and repair history, STC status, equipment conformity, operational documents, and any owner trust, non-citizen financing, or international registry implications that could affect the chain. On a large turbine aircraft, incomplete diligence is often just deferred litigation. So, where do these transactions most often go wrong? They go wrong at the seams between seller and intermediary, and between intermediary and buyer, between records access and contract promises, between title theory and registration reality, and between urgency and proof. In short, back-to-back transactions are common because they solve real market problems in business aviation. But they become memorable for the wrong reasons when an intermediary tries to occupy the economic middle without controlling the legal middle. I would like you to remember this and take this away. The safest back-to-back aircraft transaction is the one in which every party can explain in one sentence who owns what, who can promise what, and what paper proves it. Thank you for your interest in this topic. This information is provided for informational purposes only and is not to be construed as legal advice. Questions are welcome, and please direct those questions to admin@aviationlegalcounsel.com. We look forward to helping you navigate these issues with precision.